Hello, and welcome to the pre-litigation preparation stage of a civil litigation lawsuit. Before we begin, I wanted to remind you that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Just a reminder, before we get started, I just wanted to make you aware of all the documents and templates that are available to you throughout the pages. Wherever you see a light blue colored word, that means that if you click on it, it will direct you to the document and/or template that is linked to that word. These are very good resources for you at your fingertips. These templates that are available to you are simply templates. This means that you will have to alter the information in them to be true and correct to your specific case. The pre-litigation stage consists of considering settlement through ADR, deciding who to sue, evaluating and researching the case, and deciding where to file. Suing and going to court can be one of the most expensive, time-consuming, and frustrating ways to resolve your dispute. In addition, there is always a possibility that you can lose your case. So now, not only have you failed to get what you wanted in the case, you could actually end up owing the other side money. Consider other options like negotiation, mediation, or arbitration before filing your case. Alternative dispute resolution, or ADR, refers to a number of techniques that are used to help people resolve disputes outside of the court system. There are three types of ADR. Negotiation. Negotiation is simply the process of one party contacting the other party to try and work out a settlement that both parties can live with. During the course of a case, both parties are free to try and resolve their dispute through negotiation. If the negotiation is successful and you are able to reach a settlement, prepare a detailed statement outlining the terms, and there are even ways to structure the agreement so that it turns into a court judgment if one party fails to perform. Mediation. In mediation, a third party, called a mediator, facilitates the process to help the parties reach a negotiated outcome, but they do not make the decision in the dispute. The mediator is a trained professional, educated in different mediation techniques. They could even be a lawyer, a retired judge, or an expert in a particular field. Arbitration. In arbitration, a third party, called an arbitrator, acts as a private judge and makes the decision about the party's dispute. The arbitrator can be an attorney, an expert in a particular field, or a retired judge. Sometimes parties decide to submit their disagreement to arbitration because it can be faster, simpler, and less costly than going to court. Or sometimes people are obligated to use arbitration because they signed a contract that contains an arbitration clause that requires arbitration of any dispute relating to the contract. Deciding who to sue. Identifying and suing the correct defendant is one of the most important steps in your case. Once you decide who to sue, you must figure out how that person shall be named in your complaint. If you are suing a business, finding the business's correct legal name can be tricky and may take some work. Two requirements that must be met in order for a party to sue another party are that the person must have standing and capacity. Standing to sue. Standing requires that there be an actual case or controversy before one may sue, and further requires that the person suing must be the real party in interest, meaning the one who is injured and has a vested interest in the outcome of the case. Standing refers to the existence of a cause of action and the right to relief from court. Capacity to sue. Capacity refers to 1, the party having reached the age of majority, which is 18, and 2, the party's competence, meaning that they are able and capable of making decisions for themselves. Capacity assures that whatever the court's judgment is, it will be binding on the parties involved. And DOE defendants. A DOE defendant is a fictitiously named defendant. They are named in complaints to substitute for defendants whose identity is not yet learned. By naming DOE defendants, it holds the spot for the actual other defendant when you do know who they are, and it will allow you to amend the complaint to put the true and correct information in the place for the DOE defendant. Now, before you file the lawsuit, identify the parties to the lawsuit and then gather the important information about them. Ask yourself the following questions. Are you dealing with an individual plaintiff or an individual defendant only? You will need to seek their contact information. Number 2, is the defendant an employee? If so, consider whether the legal theory of respondeat superior, which is where a party is responsible for your actions and typically is an employer, and see if this is applicable. If so, you will need the employer's name and contact information as well. Are you suing an entity, such as a corporation or a partnership? If so, you will need to find out whom to serve on behalf of that entity. The Secretary of State website is usually a good place to find this information. You can search the name of the business or corporation, and there should be an agent listed who accepts service on behalf of the business or corporation. Evaluating and researching the case. You should never file a lawsuit on a whim or even consider the idea in a casual manner. Think very carefully and clearly before filing a lawsuit and always weigh the pros and cons. Is the amount of money you are suing for worth it? The following questions should be answered before filing a lawsuit because they will help you to evaluate or assess your case. Number 1, am I too late to file my case? There is a time limit on how long you can wait to sue someone. All civil cases are subject to statute of limitations. A statute of limitations is a law that defines the maximum period of time after certain events that a case based on those events can be filed. After the time limit has expired, unless there is some legal exception, you no longer have a valid claim to enforce. Number 2, are there special rules that apply to my case? In order to be able to answer this question, it will require a little bit of research on your part, which can be done at your local law library. Some situations require prior steps before considering to sue. Examples would be lease agreements and contract disputes. Number 3, do I know who and where my defendant is and where I will have to sue? You need to know where your defendant is. If you cannot find your defendant, it will be difficult to sue, but even more difficult to collect money if you win. Finally, figure out where you will need to sue. Just because you live in California does not necessarily mean you can sue in California. You will need to figure out what court has jurisdiction over your defendant and your case. Number 4, do I know the legal elements to my claim? Almost every cause of action can be broken down into elements that make up a legal claim. As the plaintiff, it is your job to know each element of your claim because it is your job to prove each one of them. To learn the elements to your cause of action, jury instructions may prove to be helpful. And number 5, do I have the evidence to prove each of the legal elements of my claim? In a civil case, the plaintiff bears the burden of proof. This means that you must provide substantial evidence, whether it be documents or testimony, to support each element of your claim. Take the time to collect all of your evidence to see whether you can meet your burden of proof. This fact chart can be helpful for you to match the facts with the necessary elements that are needed to prove your case. Number 6, do I know where my witnesses and evidence are? Locate the witness you will need to prove your case. Contact them to see if they will be willing to appear in court. If your witnesses are willing to help you, make sure you keep track of their whereabouts, keep in touch with them until trial. Do I have the money for court costs, witness fees, and the like? You must pay a filing fee to file a court case. However, if you are low income, you can apply to the court to have your filing fee waived. Even if you get the filing fee waived, there may be other costs you will need to pay, such as copy charges, witness fees, juror fees, fees for court reporters and deposition transcripts. You will likely incur other costs as well. Also, keep in mind that if you lose your case, you could have to pay the other side's attorney's fees and even court costs. Number 8, what are the chances that I will be countersued? Sometimes the person you are suing will turn around and sue you. This is called a counterclaim. Look over your case very carefully and thoroughly to try to determine whether the person you are suing is likely to counterclaim against you. This is pretty likely if the other side has claimed that you owe them money. If you think you may be countersued, make sure you are prepared to defend yourself and deal with the costs if the other side should win. Number 9, will I be able to collect anything if I win? If you win, the court does not collect the money for you. To collect, you will need to be able to locate the other side's money, assets that can be seized or sold, or debts owing to them by someone else that can be garnished, like bank accounts or employment income. Sometimes a person simply has no money to get. If they work but make under a certain amount, you cannot garnish their wages. If they receive governmental benefits like Social Security or disability, that income is likely protected under the law. It is also possible that creditors are waiting to collect judgments against the person or business. If the debtor is in serious financial trouble, they may wipe out all of the judgments, including yours, through bankruptcy. Number 10, do I have the time, energy, and ability to see my case through? Civil lawsuits may not seem stressful, but they really are. You must have the physical, emotional, and mental capacity to see the lawsuit through to the end, which could take years. The money at issue is not worth your health, not mental or physical. Number 11, have I exhausted all other options? Suing someone should be your last resort. Make sure that you have tried to resolve your case through negotiation or mediation with the other side. If there is absolutely no other way, then go ahead and file your lawsuit. Deciding where to file, jurisdiction and venue. Before you can file a court case, you must decide which court to file it in. Different courts have the authority to hear different types of cases. If you file in the wrong court, your case is likely to get dismissed. Jurisdiction. Jurisdiction is the power and authority of a court to decide a particular case or controversy. A court has the power and authority to give valid, enforceable judgments if it meets 2 requirements. First, the court must have the power to act in the particular type of case. This authority is called subject matter jurisdiction. Second, the court must acquire authority over the parties or the property involved in each specific case. This authority is referred to as personal jurisdiction. Subject matter jurisdiction. This determines whether the case may be heard in federal or state court and the proper level of court to handle this case. It may be limited or unlimited. Limited meaning the amount you are suing for is $25,000 or less, and unlimited meaning the amount you are suing for is $25,000 or more. Personal jurisdiction. For a court to have personal jurisdiction over a potential defendant, a 2-pronged test must be met. There must be a constitutionally sufficient basis for exerting jurisdiction over the person, meaning that the person was actually served with the summons in the state of California, or the person is living in California, or if the potential defendant makes a general appearance to the court where the case is filed, this submits to the court's jurisdiction, or if the potential defendant has agreed to submit to the jurisdiction. And second, the person must be given notice in a manner that meets constitutional due process and statutory requirements. This is met by the service of process. This means that you can file in any state court, particularly within the county in which you live, but always check with the court to make sure that they hear civil cases for the reason with which you are filing a complaint, because some courts have only the ability to hear limited civil or unlimited civil cases. Venue. Venue refers to the geographical location in which the case is heard. Depending on the type of case and location of the parties, venue may be proper in more than one county. The plaintiff initially chooses the venue by filing in a particular court. The defendant can dispute the plaintiff's choice of venue by filing a motion to transfer or a motion to change venue. The court in which the case was initially filed will determine which is the best place for trial of the action.